Well, I do see we are approaching our official after hours. So I will welcome everybody who is attending. I know we are live on YouTube as well. So before we jump into our Family Law Now After Hours show for tonight, I'll quickly go through a few housekeeping items. So for our Zoom attendees, you may notice that there is not a chat feature, but there is a Q&A box. Please feel free to submit comments, questions, anything through that Q&A. We do our best to keep an eye on it and get to your questions throughout our show. The purpose of this series is to discuss general topics around separation and divorce. Any information provided in this series should not be taken as legal advice. If you do have questions regarding your specific matter, please call our office or a lawyer in your area to book a consultation and to receive tailored guidance. Lastly, make sure to stay tuned until the end. We will be sharing how you can schedule a free 20-minute meeting with one of our lawyers. So now for some introductions to the dream team that we have on our screen. We have Jodeen here. She is an articling student at Russell Alexander Collaborative Family Lawyers and one of the newest members of our team. Despite her relatively short time with us, Jodeen has already gained valuable experience across both collaborative and litigation files. Her legal journey began at Queen's University, where she honed her advocacy skills through roles at the Neighborhood Legal Services Legal Clinic, and the Family and Children's Services. Oh, I did not know that, Jodeen. That's so exciting. So these experiences helped her develop a keen ability to navigate complex legal issues with empathy and insight. On your screen, you will also see Joseph. He is a compassionate family lawyer driven by a deep desire to support families through challenging times. With a background in commerce, he brings strong negotiation, analytical, and critical thinking skills to his legal practice. His passion for family law was further honed through legal writing, research, and hands-on experience in the family and children law placement at Queen's University. He emphasizes active listening, clear communication, and empathy, fostering a comfortable environment for clients to discuss personal matters. And I'm sure when I wrap up our bios, he will give us an update on his beloved maple leaves. So we also have Shanza on your screen. She is a dedicated family lawyer with a strong focus on compassionate and effective legal representation. Her background in business management enhances her strategic approach to legal matters. Shanza excels in negotiation, achieving favorable settlements through strategic dialogue and strong advocacy for her clients. She prioritizes clear communication, ensuring that clients are informed and empowered throughout the legal process. And for those of you who do not know me, my name is Stephanie. I've been immersed in family law for over 6 years now, advocating for clients both inside and outside of the courtroom. Over the course of my legal career, I've gained experience managing a diverse caseload with sensitive matters and recently obtained a successful result from an ex parte motion, which is published on Canly. What drives my passion is the positive difference I can make assisting clients through what's traditionally a difficult time by approaching matters with empathy, integrity, and compassion. So with that being said, we will jump. I'll give us a little pause to get an update from Joe of the Maple Leaf. How are things going? No comment yet.
No, so I had like a gazillion things open and I was dealing with the screen sharing. They played at night. They play against Ottawa tonight. Big game. I know a couple people going, exciting. And I mean, do they sort of suck? Yes, but not as bad as they normally do. So I like to be optimistic and it's still early in the season and we'll see how tonight unfolds.
So there's hope.
There's
Tune
always
in
hope. There's always hope. There's always
and
hope.
after hours if you're a hockey fan. After hours, after
After Hours is the place to discuss all things Maple Leafs and all things family law. It's a two for one when you
the
when you say
combo.
combo. It's a two
Absolutely.
for one.
So today we are touching on grandparents' rights in Ontario. So I'll just give a brief overview. In the past, grandparents in Ontario did not have clear rights with respect to contact or what used to be called custody and access with their grandchildren following the parent separation or divorce. However, Bill 34, Section 21 of the Children's Law Reform Act has changed that. So grandparents can now make arguments for access or parenting time or contact with grandchildren. So there's really two legislations that are at play. The Children's Law Reform Act. This applies when parents are not married. And there's also the Divorce Act, which applies when couples are married and are getting a divorce. Under the CLRA, there's section 21, subsections 2 and 3. These allow for parents of a child or any other person, including a grandparent, to apply to a court for a parenting order respecting decision-making responsibility, or to apply to the court for a contact order. So I will emphasize that the legislation does not automatically grant a grandparent the right to have access or contact with a grandchild. The court still has discretion to determine if such contact or access is in the best interest of the child, considering the circumstances. Now, if the child's parents are married or divorced or divorcing, that's when the Divorce Act will apply. And under the Divorce Act, the grandparent must seek the court's leave or permission, get permission from the court before obtaining the parenting order or contact order. Again, the courts in those situations will consider the circumstances, but those are the two avenues that sort of govern grandparent rights. The courts have held that under the Divorce Act specifically, in order for a grandparent to have a right to apply for access to a child or contact with a child, they have to establish that they already had a close relationship to the child at the time of the application and are not using the application to create or establish a relationship. Additionally, the courts have held that the grandparent access is the right of the grandchild, not the grandparent, which is why under both acts, the governing principle for granting access is a determination of what's in the best interest of the child. So we'll get into all, the details and the specifics and the tests as we go along, but that's sort of the overview so that, our audience knows those are the two acts that we're going to be touching on throughout today's show. So Jodeen, I'm going to pass things over to you. Do you mind sharing with our audience any legal requirements for grandparents seeking decision-making responsibility?
Sure. So as you mentioned, grandparents are specifically mentioned in CLRA as persons who may apply for parenting orders respecting decision-making responsibilities with respect to the child or contact orders. Secondly, it's important to note that the courts have gradually moved away from focusing solely on parental rights and biological ties in settling decision-making matters. However, depending on the judge and depending on the facts of the case, these things may still be important in considerations regarding the best interests of the child. So there was a 2021 Supreme Court decision that kind of streamlined how courts deal with weighing biological ties when considering what's in the best interest of the child. Justice Martin stated that a court may conclude that if the evidence supports assigning weight to a biological tie, if it can be made to, sorry, my bad. Let me say it again. So Justice Martin stated that a court may conclude that evidence supports assigning weight to a biological tie if it can make the link to a child's best interest. That said, a biological tie in itself should carry minimal weight. Further, Justice Martin added that parental preference should not usurp the focus on the child's best interest. All this to say is that parents don't necessarily get a pass simply because they're biologically related to the child. It really is dependent on the child's best interest. And so grandparents are able to make decision-making claims and applications on the grounds that they are, grandparents. They don't have special standing, however, they are able to make those decision-making claims. And of course, that's subject to the best interest tests that the courts will conduct. Additionally, grandparents can seek interim relief like temporary parenting or contact orders through motions. Another way that grandparents may make claims to decision-making responsibilities is if they have stood in the place of the parent. That's a legal concept called local parentis. So that's if the grandparents have cared for or have had control of the child, and there are provisions in the family law rules that require that if that's the case, then the parents, then the parties, they must be added to the parties to any proceedings affecting the child unless the court orders otherwise. So those are some circumstances in which grandparents may apply for this decision-making responsibilities for their grandchildren. Over to you, Steph.
Thanks, Jodeen. Yeah, it's there's a few different loops or hoops, sorry, that grandparents might have to jump through, especially because they're might not ordinarily be the primary caregiver or caretaker. But Jodeen highlighted a really key legal principle, that locus parentis, that can come into play. Shanza, do you mind maybe touching on some factors considered when courts are a case like this comes across the court's desk and they have to consider, the best interests of the children?
Yeah, so you've mentioned this stuff, and Jodeen, you too, sorry. Bit of a cough there. Yeah, so when it comes to children, the first thing the court refers to, and this is regardless of whether we are dealing with parenting time for co-parents or if for the purposes of today, grandparent contact, is what stuff you mentioned, Jodeen, you mentioned, is the best interest of the child. And the Children's Law Reform Act, CLRA, has all these factors. It emphasizes that in decision-making regarding the children must prioritize their best interest. And so the court will look at these factors under the CLRA for grandparents' access to determine, whether a contact order or decision-making order, depending on the type of claim that the grandparents are bringing, whether that should be made or not. So what are these factors? Let me go over a few of them. So these include looking at the child's needs. So this is given the children's age, their stage of development, such as the child's need for stability. And the courts will consider a potential impact of the visitation from grandparents on the child's routine, their stability, and their overall well-being. And the courts aim to ensure that visitation, it does not cause any undue stress or any negative consequences for the child. And the factors also consider things like the nature and strength of the child's relationship with the grandparents. So a strong bond and a history of active involvement can really strengthen a grandparent case. Like stuff you mentioned, like the application isn't about, forming that relationship. It's about maintaining that relationship and the child's right to having that living relationship continued with their grandparents. The court will look at each parent's willingness to support the development and the maintenance of the child's relationship with the other parent and grandparents, and vice versa too. So the grandparents' involvement in not negatively influencing the child's relationship with the parent. So all parties and their conduct, everything is taken into account to assess whether, such an order is in the child's best interest or not. And this means that the strength and stability of the relationship between the parents and the child will also come under scrutiny. If the parent-child relationship is already strained or unstable, the court may be more inclined to consider a grandparent's contact claim more seriously. I don't know if I mentioned the history of care of the child, the involvement of grandparents in the children's lives. The child's views and preferences can also come into account, and this is depending on the child's age and maturity. So the older they are, the higher weight this might be given. Unless the children are too young, in that case, their views and preferences do not hold a very, very strong a value. The ability and the willingness of the grandparents to care for and meet the needs of the child is also an important consideration going forward. So if there is any visitation and contact given to grandparents, are they able to care for the child and meet their needs? Any family violence and its impact on the people to care for the children, all of that comes into account as well. Something else considered is also cultural, linguistic, religious, and spiritual upbringing and heritage. So all these factors, they kind of come in together for the court to decide what is in the best interest. Essentially, all these factors, what they're trying to determine is the safety, the security, and the well-being of the child. I think another important question when we're dealing with grandparent contact is the balance between the parental authority versus the children's relationship with the grandparents. And so some additional factors the court might look at is, is there a positive grandparent-grandchild relationship? Has the parent's action or decision-making negatively impacted that positive relationship because it's the right of the child to have that relationship with the grandparent? And so if the parents have acted arbitrarily to implicate this relationship between the grandparent and children, so the courts will take into account the parents' wishes regarding visitation as well. If both parents are against allowing access to grandparents, the court will determine why that is, and whether that decision should be respected. Unless exceptional circumstances exist, the court may find that it is in the best interest to continue that contact for grandparents.
Thanks so much, Shanza. Yeah, that was a great breakdown, especially of the best interests of the child, specifically when dealing with grandparents and not just between two separating parents. Jodeen, I'm just going to flip things back over to you. Do you mind touching on maybe some other rights of grandparents in cases of separation or divorce, and maybe even some challenges as well that the grandparents might face in pursuing those rights?
Yeah, thanks, Steph. I can definitely touch on the challenges grandparents may face. I think that Shanza also touched on a few of them in her response as well. So I'll just build on that. So when it comes to like establishing decision-making claims, grandparents may find some issues really establishing or proving that the parent is unfit for making decisions in the child's best interest, because there's a tendency of the court to favor more so the parent's decision-making responsibilities. So it may be that even in situations where maybe that the parent left the child with the grandparent while trying to improve their own situation, but still stayed involved in the child's life, maybe the court might still favor returning the child to the parent because the court wants to, ensure that the child has a good relationship with their parents. So a challenge for the grandparent would be to, harkening back to what Shanza said, is establishing a good argument that it is in the child's best interest to remain with the grandparent long term, and that this was not just a temporary thing. That is in the child's best interest to stay with the grandparent, and that's where the child will thrive or continue to maintain contact with parties that build relationship with friends and family and things like that. So that might be one difficulty that you may have to overcome. Another difficulty, as I said before, about there is some case law that has established that parents have some kind of preferred status, even though the Supreme Court decision in 2021 kind of overrides that. Sometimes it takes the law some time to catch up, because the decisions are made within the courts. So you have to be mindful that there may not be it may be a challenge establishing those arguments, but it can be done if the facts of your case align, and you're able to convince the judge that this is in the best interest of the child to remain in your care, and that under your care, the child has been thriving. So that's in terms of decision making. Contact issues with contact, difficulties that commonly arise is that maybe the parents oppose contact with the grandparent. So when the children's parents are living together and choose not to allow contact with the grandparents, that may cause, that may be difficult for you to overcome, because the courts tend to respect the parents' authority in decision making. However, this is not to say that grandparents can't bring claims for contact. As Steph mentioned earlier, under the Divorce Act and under the CLRA, you can do that. And under the considerations that the court makes for best interests of the child, relationship with the grandparents is one of those considerations. So all hope is not lost. There's still a way to, make those arguments. And as you can tell, a lot of this really comes back to the best interest of the child. And that's really where the base of your, a claim might be. And so that's where I'm gonna hand it over back to you, Steph.
Thanks, Jodeen. Yeah, I definitely think, maybe not necessarily cases that have come through our office, but just concerns that you hear from grandparents or soon to be grandparents. What are my rights? I don't think my, daughter-in-law, son-in-law, whomever will foster a relationship between me and my grandchild. How is that possible? But one of those big uphill battles that those types of parties will face is if you didn't already have an existing relationship with the grandchild, it will be extremely difficult to bring an application to pursue those rights under the legislation. That being said, it doesn't mean that there's no hope, that there's no alternative. Perhaps those parents or grandparents rather would seek assistance through alternative dispute resolution to try to rebuild and refoster their relationship with their child in order to benefit and foster that relationship with their grandchild. Shanza, do you mind maybe touching on some alternatives to court in order for grandparents to resolve those disputes and foster that relationship with any grandchildren?
Yeah, it's always good to consider alternatives to litigation and going to court. Litigation in general can be a lot more expensive, stressful, and it's also less flexible. Litigation is more suited for situations where there is, not a lot of room for compromise. There's high conflict situations where parties aren't really willing to negotiate too much. But other than that, if you feel like you're in a, if there is room for negotiations and there can be some dialogue initiated, alternatives to going to litigation can be less time consuming and less emotionally draining as well. So for alternatives, we are looking at mediation. Mediation involves a neutral third party, the mediator, that can facilitate discussions and negotiations between the grandparents and parents to reach an agreement. These third parties are experts and they're trained to facilitate these discussions to help reach solutions that are creative and more applicable to the facts and the situations at hand. Mediation is less adversarial than court proceedings, and that can help maintain or even repair relationships. And it can really help focus on solutions that best serve the children's interest. It can also be faster and more cost-effective than going to court. And then collaborative family law is another option. In a collaborative family law process, each party, they hires a lawyer, and these lawyers are trained in collaborative practice. The parties, including the grandparents, can meet and work together with their lawyers to negotiate and resolve disputes without necessarily going to court. And this method, it promotes open communication, it promotes transparency and a cooperative approach. There can also be experts who can come in, like family professionals, in these meetings, and they can really guide these conversations and really assist the parties in coming up with resolutions. All in all, it's a collaborative process where everyone kind of works together to get to a resolution. There's also arbitration. Arbitration involves an impartial third party arbitrator. It's slightly different from mediation because the decision is a binding decision. And this binding decision the arbitrator will reach after hearing evidence and arguments from both sides. This is more formal than mediation because of that, but it's still less formal than a court trial or court proceedings. Arbitration can be faster than the court process, and it allows for more control over the process, the scheduling, the selection of the arbitrator. It's also private, unlike court proceedings, which can be public. Negotiations, that's usually the first step. Parties will attempt direct negotiation to reach an agreement. Having lawyers involved is really helpful and important, because if you have a lawyer, they can really guide you. They can guide you on your rights. They can guide you on your obligations and what's a reasonable position to hold. And they can facilitate conversations with the other party, especially if it's harder to have those conversations personally. And if both parties have counsel, it can be really helpful to move the matter forward. I mentioned parenting coordinators before as part of the collaborative practice, but a parenting coordinator in general can be involved outside of the collaborative process as well to assist in resolving and facilitating discussions regarding access arrangements. They are typically used by parents, but the same principles can apply when grandparents seek access to grandchildren. And this process is focused on, it really helps kind of drill down practical solutions and helps parties reduce ongoing conflict by providing, by having the guidance of a parenting coordinator who are experts at resolving these issues. So is it worth considering alternatives to court? Yes, it is. It's less stressful. It's there's times and cost savings involved. I think preservation of relationships is an important piece as well. A less adversarial process between parties really help maintain relationships because of its less adversarial nature. Also, ADR can be more flexible and it can give really tailored solutions, which I find are not always possible when you're going to court.
Yeah, 100%. And I think you really touched on it when talking about fostering relationships and, mending relationships. For whatever reason, there is likely a reason why grandparents are, not in contact with their grandchildren. It could be due to, family drama or family events that really broke down a parent's relationship with the prospective grandparent. And alternative dispute resolutions, not only can you come to a resolution on grandparent contact, but it might help mend those wounds or fix some of the broken pieces to help build the family to getting back on track. Ultimately, there's so many positive components that come with a grandparent's involvement to a children's well-being, having extended family members, understanding their roots, their heritage, their culture, and just having more family members. It takes a village to love and support and nurture that child. There, of course, are reasons and, extremely justified reasons as to why that contact might not be appropriate. But that's one of the things that the court considers when navigating these types of cases. There are other positive impacts to grandparents' involvement. It's, cost-free childcare, support, driving. I don't know about any of you, but my grandma, I can't even count the amount of times that she picked me up from school, or there was a PA day and, she lived around the corner, so it worked out. So those are just things for parents to bear in mind when considering mending those relationships or working on those relationships in order to support your child's relationship with their grandparents. And that goes for both sides and extended family members as well. So Joe, you've been a little quiet there.
I've been soaking in all the knowledge that you guys have all been sharing with me today.
Yeah, do you have any recent legal developments that you could share with our audience that affect grandparents' rights in Ontario?
Yeah, I mean the big predominant ones we've already have discussed today. There's the change back in 2016, as we mentioned, with the Ontario Children's Law Reform. So I'll speak about that again. I know everyone sort of touched on it a bit. I'm just going to expand a bit on it, and then I'm going to deal with the most recent precedent-setting case regarding grandparents' rights. So, in Ontario, pretty much not even specifically in Ontario, but Canada as a whole, as Steph mentioned, grandparents have historically not had explicit rights to contact their grandchildren after parental separation or divorce. However, going back to the recent updates to family law as a whole, but specifically through Ontario's Children's Law Reform Act, so this is provincial legislation, it's not federal legislation, it's provincial. It now acknowledges really the importance of maintaining family relationships in a child's life, including connections with grandparents and their grandparents. It's put Ontario on the map with other provinces such as Nova Scotia and Manitoba with respect to grandparents' rights. And under these laws, grandparents can now seek access through a contact order. I know we've gone back to saying that the terms custody and access are no longer used. However, with respects to certain groups such as CAS, for example, the Children's Aid Society, they still actually use custody and access, and the term contact order is still used. And grandparents can seek contact with their grandchildren if they can, as such, demonstrate that their contact aligns with, as always, what we've spoken about today, what we've spoken about last week, the week before. It always seems to flutter in is, once again, the child's best interests. And that's done through Section 21(2) of the Children's Law Reform Act. And that section of the legislation allows any person, explicitly including grandparents, to basically apply to the court for this contact order. And the legal process does require grandparents to provide evidence supporting their claim that access is beneficial for the child. That's important. It's not beneficial to them, but it's beneficial to the child. And that's typically through what's called an affidavit, and that is filed with the court. And then it is then the grandparents' responsibility to prove that the order they're seeking in the contact serves the child's welfare and well-being. And given that Ontario is, they have their own provincial laws, the Canadian government has, federal legislation, family law in and of itself deals with both, provincial and federal legislation. It's just one of those areas of law that does so. The Children's Law Reform Act applies specifically to situations where parents are not married and they are only separated. In other words, they're not married, either they are common law or they may have not reached the formal declaration of being a common law partnership, and they just have a child together, which is possible. Parties don't always have to be necessarily in a common law to have a child together. And when parents are in the process of divorce or they've already have divorced, the federal legislation, the Divorce Act, as Steph mentioned, applies instead. And Section 16.13 of the Divorce Act requires non-parents, which is in that sense including grandparents, to obtain, as Steph mentioned, the court's permission to actually apply for a parenting order. And Section 16.5.1 actually allows the courts themselves, they have an inherent jurisdiction to establish contact orders for non-parents, i.e. grandparents, if the court deems, once again, that is in the child's best interests. And courts, there is a test that the courts use. It is found in both the Children's Law Reform Act and the Divorce Act, but they evaluate not only that, but several other factors to decide whether contact should actually occur within a parent's designated parenting time. So that's the legislative component. That's sort of the most recent updates to grandparents' rights with respect to legislation is found in the Children's Law Reform Act. Now, In terms of precedent-setting cases, or I should say at least notable precedent-setting cases, has to do with not legislation, but it's actually case law. And that's where, party A and party B go to a trial, or they might have a motion. Regardless, they're in the court system, and the decision that a judge makes is binding, is precedent-setting. So that's where we have the term precedent. And it comes from a 2005 Ontario case, Jasante and Dicharia. It's a Court of Appeal decision. And that notable precedent actually establishes a three-part test for assessing grandparents' access rights. I know Steph sort of brought it up and everyone else has sort of talked about it, but we're going to go into a little bit more detail. And the three-part test, all parts have to be there has to be evidence to substantiate each part of the test. It can't be a one of three type of thing or a two of three. All three prongs of the test need to be met. So the first prong, again, is whether a positive relationship exists between the child and the grandparent. That's number one, that has to be proven. Number two being whether the parent's decisions have harmed this relationship, and that's after the first prong obviously has been met. And the third, if both a positive relationship exists and the parent's decisions have actually harmed the relationship, the third prong that the grandparent has the onus or the responsibility to prove is whether the parent's actions were either A, arbitrary, or B, without a valid reason. So if a grandparent can demonstrate that, the parent or parents could be plural, is unfairly hindering, this beneficial relationship to the child, which at the end of the day, more often than not, a child having a relationship with a family member is beneficial, unless you can explain for reasons, that Steph's mentioned, whether their well-being or safety is at risk. The more the merrier. There's never a wrong reason to not incorporate additional family members into your child's life. And like I said, so if the grandparent can demonstrate these three prongs and they can pass the test, then the court may, and that's the key word, may intervene to protect the child's best interest, and that's by actually issuing this contact order. So we have the legislation update, which 2016, it seems like years ago, and then we have this notable case law precedent, which is even longer than 2016, back in 2005. But I mean, the province has definitely come a long way with aligning itself with other provinces in the country with respects to grandparents' rights. Some advocates say it's not enough. Some say that it's just fine the way it is. But I mean, regardless of what side of the equation you believe yourself to be on or support, this is where we're at. This is the case law that's supporting it. This is the legislation that we have. So this allows grandparents to, or at least have the possibility, I should say, of getting this contact order, because there is no inherent right to contact with a grandparent and the grandchild.
Yeah. And just to build on that, like Joseph mentioned, it's very, very particular to the set of circumstances in your case. The evidence, affidavit, or otherwise is going to be instrumental in guiding the court to their decision. On the flip side of the case that Joe mentioned, there was another case, Chapman and Chapman, and it was a grandmother.
Which is even older.
It's even older. Yeah. So this was a circumstance where this grandmother wanted to have contact with her grandchildren, who were, I believe, 8 and 10. The parents did admit, they said that a relationship with between the children and the grandmother would be beneficial. However, it was a poor relationship that existed. So this actually ended up going to the Court of Appeal, and the Court of Appeal made it clear that parents who are attentive to the children's needs, it can be left up to them to set contact terms with grandparents. The facts of this case in particular, they took care of the child, they were attentive towards its needs. There was really no reason to believe that they weren't making a sound decision. But if there was any evidence on the flip side of that, the case might have gone a different way. So it just goes back to what Joseph mentioned, those three prongs, and the facts of the particular case. So things to bear in mind if you're considering bringing an application or pursuing your parental or grandparental rights, in a sense, just to make sure that when you are pursuing that avenue, that you consider those.
And I just want to throw in, sorry, it's you have to consider it as well, but on the flip side, you have to see whether or not, if you're dealing with parents like you said, who may not want you in their child's life. Like I said, if there's a beneficial or a real reason or not an arbitrary reason why they're not allowing you in their life, that maybe that should be something that should be reflected on first before you seek legal advice, and B, even if irrespective, if you don't believe necessarily that it's the right decision, before commencing the application yourself or seeking leave to the court to seek to commence the application, really, really important that you speak with a legal advisor. You retain a counsel for the purpose of independent legal advice. They can save you thousands of dollars. They can provide you different alternatives, like Shanza mentioned, with respects to alternative dispute resolution. You don't always have to go to court. Most often, and that people forget, is that you can solve so many issues without going to court. There are so many other avenues available to you. And just because you're not going to court doesn't mean that you cannot get advice from a lawyer to even help you guide you through the process as well. So I mean, if you think you have a case that fits, even before starting or even attempting to start, it's really important that you get some legal advice to at least provide you with an insight on how likely or if likely at all that your claim can succeed.
Absolutely. Great advice. So I'm just gonna open, and that's Joe. Do you have any other support services or groups that you could recommend to our viewers who might be struggling with this?
Yeah, I mean, there are local kinship supports in every community. I know they have a big one out in Belleville, in Cambridge. I mean, more often than not, there should be local kinship support or grandparent support groups in your community. What you should be looking out for are groups that are designed for grandparents, or even not just grandparents, but other relatives who maybe have taken on the role of raising a family member, i.e. children. And it offers us, usually it should offer or should be offering a supportive environment where members can exchange information, get some practical advice, encouragement to navigate unique challenges of unexpected parenting responsibilities. And it's really great for peer-to-peer support. I mean, aside from these groups, speaking with a mental health professional, if you find yourself involved or inundated in a heating parenting battle, maybe through your fault or not, or through, not fault of your own. But family professionals such as social workers or psychologists are sometimes a great place to start. Will help you gather emotions before deciding on next steps. We spoke about it last week. Having strong mental health and having a clear head allows you to be more effective in the legal process, allows you not to maybe jump to necessarily to other conclusions that you may have necessarily would have jumped to, allows you to have some sound thinking and decision making. So being able to speak with someone, there's a wide range of mental health professionals that are out there available to assist you, or even going to a close friend or family member who's maybe not entangled in this ordeal, someone who can give you a third party expert or a third party view, or someone who's not directly associated with it, who can give you a third bird's eye view opinion. That's also a great place to start. Then once you've sort of been able to tackle that on the support side of things, and you've been able to at least get a clear picture of the situation at hand, that's when I would start looking around and contacting legal services in your area to see how they can help you and the children in that particular situation, whether that's through the Law Society of Ontario website. You can find great lawyers there. Legal Aid Ontario is a good way. Every courthouse in Ontario has a family law center where sometimes duty counsel's present, and they can give you advice on on a pro bono basis, and there's some great resources there. So I mean, in terms of where to start, look for the support aspect first, and then once you have the support aspect down pat, that's when you can start looking for legal support.
Yeah, great tips, Joe. And that's, I know this was a little short and sweet this time. Grandparent rights are a little bit more of a niche area. But we do want to thank everybody for tuning in to After Hours today. For our Zoom attendees following this webinar, a brief survey will appear, allowing you to share your comments and suggestions for future topics you'd like us to explore. Your feedback, as always, is greatly appreciated. Also, to take advantage of the opportunity for a complimentary 20-minute meeting with one of our lawyers, please provide the code After Hours when scheduling your appointment. You can do so by calling our office. We do have operators standing by now to take your call, or you can email our intake department at intake@russellalexander.com. We do ask that you try to register by noon this Friday. Your appointment doesn't have to be by noon this Friday, but we want to make sure that we get everybody in. Also, registration for our next event is open. So we will be talking about alternative dispute resolution and family law, into a deeper dive of that. So to register, just go to russellalexander.com/family law now. Again, to our panelists, thank you so much for sharing your insights today. And thank you to our audience on Zoom and on YouTube for tuning in. And we'll hopefully see you next week.
Thanks, Steph. Great hosting today, and bye everyone. Thank you.
Thank you,
Bye,
everybody.